Gábor Lukács has been fighting for a passenger Bill of Rights for years. He's an air passenger rights advocate, and I spoke to him earlier from Halifax. Hi, Mr. Lukács. Nice to see you. Thanks for your time.
Good evening.
Let me get your quick take. Is this new set of draft regulations, is it good news for passengers?
This is bad news. The government is clawing back on the rights of passengers under the disguise of an air passenger bill. This is a slap on the face of Canadians.
Okay, let me ask you to expand on that first. Give me some detail as to why you think that's the case. Why? I mean, the government is presenting this as we've got more regulations. There are fines if your bags go lost. There are fines for staying over 3 hours on the tarmac, things along those lines. Why is that bad news for passengers in your from your perspective?
Let's first clarify, there are no fines. Airlines have never been fined for breaking the rights of passengers. That's part and parcel of the problem, the lack of enforcement. But as for what is in the regulations, first of all, the regulations confirm the doubling, in fact more than doubling, the amount of time passengers can be kept on an aircraft on the tarmac from 90 minutes to more than 3 hours. That is simply inhumane. Second, the proposed regulations relieve airlines from compensating passengers if a flight is delayed or cancelled due to the airline's own maintenance problems. If the aircraft breaks down, the airline can claim it was a safety issue and just not pay compensation. It results in an unenforceable, unverifiable scheme.
I want to ask you about enforcement in a second, but let me ask you also about the point about maintenance, because I did ask the minister about that. I guess you could call it a loophole. And he said, well, that's the way the U.S. does it as well, and the system works there. What's your response to that?
Minister Garneau is mistaken. In the U.S. and across the world, the Montreal Convention is the leading regime. Under the Montreal Convention, most maintenance issues are not exceptional circumstances. They don't relieve the airline from paying compensation. I personally obtained a judgment in 2009 against an airline when the aircraft broke down under the Montreal Convention. So when you look at the European regime, which incorporates and further develops the Montreal Convention, it is settled law that when an aircraft breaks down and the passenger is delayed or cancelled, the airline has to pay compensation. No questions, no excuses. The only time an airline can avoid paying compensation in Europe is if it was, say, a volcanic eruption or a snowstorm or an act of terrorism, sabotage, or if all planes of a given model are grounded. But if it is only one airline's one plane, not something affecting all airlines equally, it is the airline's own problem. It is their aircraft, their fleet, they are responsible for maintenance.
You also touched on enforcement or lack thereof, and I asked the minister about that a couple of times. And basically the premise of my question was, if you are bringing in all these new rules, are you prepared, if necessary, to devote more resources to enforcement? I want to play a clip of what he had to say and then get your response. Take a listen.
We're doing this for the first time in Canada, and if you look at our rules and compare them with the European rules in their entirety and the American rules, you'll see that the Canadian rules are actually the most demanding and the best rules in the world. We already have the resources in place to monitor our Canadian airlines.
So let me drill down again into that last portion of the minister's answers. We already have the resources in place to monitor our Canadian airlines. What do you think about that?
Well, first of all, the rules are far superior in Europe than in Canada, so the minister is mistaken as to that. In terms of resources, what is missing in Canada is the will to enforce the rules. Rules have been on the law books for decades. For example, it is unlawful to mislead passengers about their rights. It carries a fine of $25,000 for each incident. Yet, not a single fine has ever been issued on that basis by the Canadian Transportation Agency. So it is the appetite for enforcing the law that is missing and will continue to be missing, and not the resources.
Where is that appetite missing from? Is it the political will? Like, should it come from the government? Is it the CTA? Is it where do you find, if that is the case, that the appetite is lacking?
Both. We have a transportation minister who has taken away rights from Canadians to make airlines more profitable. And we have a Canadian Transportation Agency that has been refusing in practice to enforce the rights of passengers, rights that are already on the law books, that are already known, and all it would take is enforcement officer who is willing to do their job. They have adjudicators who adjudicate disputes between passengers and airlines, but as it turns out, one of those adjudicators is actually married to a lawyer who is on the airline's payroll. So we don't have an independent, impartial adjudication of complaints. Passengers with valid complaints are being turned away by the Canadian Transportation Agency, and they are not using the substantive enforcement powers that the law already confers on the Canadian Transportation Agency. They can issue fines for, in some cases, up to $10,000, in some cases up to $25,000 per incident. If those powers were used, airlines would very quickly start complying with the law, but they are not being used.
These are draft regulations that are open now for public comment. Do you plan to submit your comments, and what's your level of optimism that the final rules will better reflect, I guess, some of the concerns that come forward?
We will be making submissions, but we have no hope in reality that they will be actually listened to. You have to bear in mind that those regulations, those legislation that have been pushed through Parliament have been criticized and opposed by the Senate. The Senate told Minister Garneau that those regulations, that entire framework that he came up with was inadequate. Senate told Garneau that keeping passengers on the tarmac for 90 minutes is the maximum. He should not allow airlines to hold passengers captive on the tarmac for 3 hours or more. But Minister Garneau chose to ignore those warnings and just reintroduce the bill. So we have a minister, a government, and a Canadian Transportation Agency that is clearly not willing to listen to what the public has to say, to what concerns Senate had, and we anticipate that this additional round of consultation is another dog and pony show.
To be fair to the government, I mean, that is their prerogative, and they have in other cases. You know, the Senate will propose amendments, and they will ignore them. And on the point that you brought up about 3 hours, and I take your point that it is double what was originally, 90 minutes to 3 hours on the tarmac. The minister says, well, during those 3 hours, we've now ensured that there will be food and water, there will be Wi-Fi. There's a whole host of conditions that need to be met if, in fact, the plane is there for 3 hours.
It is entirely irrelevant, because if you think of someone who is a person with disabilities or a little child, it is not the food necessarily that they are missing, but possibly the actual real ability to go to the bathroom. When you are wheelchair bound, and I've heard it from the Canadian Council of Disabilities, and you sign up to have a 2-hour flight, you don't sign up to have a 5-hour flight, which would be 3 hours of tarmac delay plus 2 hours of flight. So this creates significant problems for families with small children, for passengers with disabilities, and there is no justification for it other than catering to the airline industry.
Okay, I'll leave it there. Thank you so much, Mr. Lukács.
Thank you very much for having me.